Civil Litigation, a survivor's guide to suing in Ontario. Today, I'm going through the main points that you as a survivor need to know about civil litigation and suing for sexual assault in Ontario. I'm Natalie Gary, the principal lawyer and founder of Gary Law. I help injured people, and especially those affected by sexual abuse, get the compensation they deserve for their injuries. Let's get into this topic today so that you can hopefully understand what is involved in the civil litigation process, so you can feel a little bit more empowered about your options for taking legal action. If you've experienced sexual violence or intimate partner violence, filing a civil lawsuit could be an option to seek compensation for the harm done to you. I'm going to go through and explain the process in Ontario, your rights, and the key steps involved so that you can better understand your options. So first of all, let's talk about what even is civil litigation. Civil litigation is the legal process where one person, known as the plaintiff, sues another person, group, or business, which is called the defendant, for harms they've caused. And the purpose is to provide compensation to the person who has been harmed. So the primary purpose of the civil law system is to provide compensation to the person who has been hurt or harmed by another person's actions. For example, if someone's actions caused you emotional trauma or financial loss, you could sue for damages such as therapy costs or lost wages. You might be wondering, how is civil litigation different from criminal cases? And I'm going to contrast the two so that you can understand a little bit more about the differences. So the goal of a civil lawsuit is to compensate the survivor, whereas the goal of a criminal case is to punish for the crime. And in the criminal case, it is more society who is bringing the criminal action against the perpetrator because society has an interest in keeping order, as opposed to the victim or survivor who is bringing the action. In the criminal case, the victim or survivor is a witness, not the person bringing the action. The party bringing the action is actually the Crown or society. In a criminal case, the decision has to be made based on the standard of beyond a reasonable doubt. So this is close to absolute certainty. Whereas in the civil system, the decision is based on a balance of probabilities. So this is a more likely than not standard, or a 50% plus one standard. In the civil case, the survivor is called the plaintiff. And in the criminal case, the survivor is often called the witness or sometimes the complainant. In a civil case, there may be limitations that apply, but in Ontario, usually there are no limitations. In a criminal case, there is no time limit for reporting sexual violence, so this is one similarity between the civil and the criminal system. In the civil system, the survivor controls the lawsuit, whereas in the criminal system, decisions are largely made by the Crown attorney, who is not the attorney for the witness or survivor. The Crown attorney is representing the public and is trying to find basically a just outcome and is not advocating necessarily on behalf of the survivor. You might be wondering, what is a cause of action? So a cause of action is the legal reason you can sue someone. It means that what happened to you is recognized as a legal wrong under the law. Examples of causes of action in sexual violence or intimate partner violence cases include assault, battery, and intentional infliction of emotional distress. You might be wondering, what is the time limit to sue in Ontario? So in Ontario, for most personal injury actions, there is a basic limitation period for filing a civil lawsuit, which is 2 years from the date you become aware of the harm. For sexual assault or violence related or sexual violence, there is no limitation for starting a civil suit. So there is no time limit for suing in cases of sexual assault, domestic violence, or where the survivor was under the care or authority of the defendant. For example, a teacher, a coach, or a caregiver. It's important to check with a lawyer about specific limitation periods because this can be complicated, so it is important to get tailored legal advice to your situation. Some of the options before going to court. So you may not need to go to trial to get compensation compensation for the wrongs that have been done to you. There are alternative dispute resolution methods, including negotiation. So you or your lawyer work directly with the defendant or the defendant's lawyer to reach an agreement. There's also mediation. So then a third party neutral mediator would help both sides to discuss their issues and hopefully find a solution. There's also arbitration, where both sides agree to let an arbitrator make a decision, and this can be binding or non-binding. And it's similar to mediation, but the decision can be binding if the parties agree. These options can save time, money, and stress compared to going to trial, because the civil litigation process can be lengthy and expensive, and it can get stressful, so that it's good that there are alternative dispute mechanisms that can resolve claims more quickly. You might be wondering what happens during a civil lawsuit. So the first step is filing the claim. So it may be filing the claim, or there may be some negotiation before filing the claim. It depends on the tactic that you wish to take and that your lawyer recommends. So your lawyer can prepare and file a statement of claim to get the official lawsuit started and filed with the court. The statement of claim explains what happened and why you're suing. This document is served on the defendant, who must respond with a statement of defense. Step 2 is the exchange of information. So this is also called discoveries. At this point, both sides share evidence like medical records, emails, or witness statements through the discovery process. Discovery ensures that both parties know the evidence before trial, and this can facilitate a settlement, because once you know the evidence of the other side, then usually a settlement is easier to come to. Step 3 is settlement or trial. So most cases do settle before trial, and settlement can happen at any point in the process, even up to the day of trial or even before the statement of claim is filed. If the case goes to trial, both sides present evidence, call witnesses, and make arguments, and then the judge decides if the defendant is liable, which means legally responsible, and if so, the judge also determines the amount of compensation. In terms of the amount of compensation, these are called damages. So damages are money awarded to compensate you for the harm that you've experienced. And types of damages include, first of all, non-pecuniary damages. So these are damages for pain and suffering and loss of enjoyment of life. So for example, this could be emotional distress caused by the harm. The second type of damages is special damages. So this is damages for aspects of your loss that are sometimes easy to calculate. So it's things like medical expenses or lost income. For example, therapy bills or wages that were lost due to missed time at work because of what happened. The third type of damages are punitive damages. So these are awarded to punish the defendant for a purposeful and harmful action. So for example, if the defendant's actions were cruel or malicious, which in most cases a sexual assault case, punitive damages will be awarded, except for usually in the case if the defendant has already served time or has been punished in the criminal system. Usually punitive damages would not be awarded in the civil case. The other type of damages are aggravated damages. So this is compensation for additional humiliation or emotional harm, and these are quite common in sexual assault or abuse cases. An example is if the defendant's actions caused public embarrassment. You might be wondering, how are damages calculated? So some damages are straightforward, like the medical expenses that are supported by receipts, and others like pain and suffering are harder to measure and depend on various factors like the survivor's age and vulnerability, the severity and frequency of the harm, the lasting impact on the survivor's life. So the judge may look at these factors and will also look to other case law to determine the appropriate amount of damages. Another thing to mention and know about is about class action lawsuits. So in some cases, survivors can come together and file a class action lawsuit if they were harmed by the same person or organization. So for example, a group of survivors sues an institution for failing to prevent or address sexual abuse, which resulted in a group of people experiencing sexual abuse around the same time or by the same institution. Class action lawsuits are becoming more common in cases of institutional abuse. The last thing to know is about why to consider a civil lawsuit. So filing a civil lawsuit is not about punishing the defendant. It's about seeking compensation to help you recover financially and emotionally. And it's also about accountability. So it's about holding the defendant responsible for their actions. Another aspect of this is control. So unlike the criminal case, you as the survivor have a lot more control in the civil process, because when you hire a lawyer, you are telling them how you want to proceed, if you want to settle, if you want to pursue it, and you are much more in control than you are in the criminal process where you are treated as a witness. You might be wondering where you can get support. If you're considering a lawsuit, it is very important to have the right support. There are various lawyers who specialize in sexual assault cases in Ontario, and I can always be reached at the contact information below, and I would be happy to discuss your particular circumstance.